Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning and welcome to the March 31st session of the Court of Criminal Appeals at Knoxville. Let me introduce the panel to you. To my left is Judge John Everett Williams from Carroll County, and to my right is Judge Robert Holloway from Murray County, and I'm Robert Montgomery from Sullivan County. Each side will have 20 minutes for oral argument. If you're the appellant and wish to reserve time for rebuttal, please let me know as you begin your argument. Madam Clerk, are there any preliminary matters?
No, sir.
Okay, would you call the first case then, please? State
of Tennessee versus Douglas Ferguson.
Okay, let's see. You're Mr. Rader?
Yep.
All right, you may proceed then. Do you wish to reserve any time for rebuttal?
Yes, I'd like to reserve 2 minutes for rebuttal.
All right. Okay, you may proceed.
Good morning, Your Honors, and may it please the court. Patrick Rader on behalf of the appellant, Mr. Ferguson. I'm here today appealing the trial court's denial of probation in this case. But before I get into my legal arguments today, I'd like to give a brief background of the procedural history in this case. In December, I was here arguing before a different panel of the court, arguing that the trial court had erred in revoking Mr. Ferguson's probation in a different but related case. These two cases are related because the trial court revoked Mr. Ferguson's probation simultaneously to its decision to deny him probation for the new charges in this case. These two decisions were made on the same day, at the same sentencing hearing, and were based on the same evidence presented at the sentencing hearing. Therefore, the arguments that I've made in both appeals are very similar to one another, and with the addition of a few arguments unique to this case. But to give a bit more background, in June of 2018, Mr. Ferguson was serving 5 years on probation for 2 counts of aggravated assault against his neighbors, the Rosenbaums. In June, he was charged with new offenses after confronting his son, Wade, with a chainsaw. He was eventually convicted of aggravated assault for this case. Mr. Ferguson's actions were caused by what almost every witness at the sentencing hearing called dementia. Mr. Ferguson's ailing mind, coupled with his mistaken belief that he owned his son Wade's property, resulted in him confronting his son with the chainsaw. This also resulted in the loss of Mr. Ferguson's right leg after Wade ran him over with his riding lawnmower during the confrontation. But by the time of the joint sentencing hearing and revocation hearing, Mr. Ferguson was 77 years old, and the trial court revoked his 5-year sentence on probation and ordered him to serve another 5 years in prison, and then eventually ordered that these two sentences run concurrently. As I previously noted, Mr. Ferguson has already appealed the revocation of his probation in the other case, but we're still waiting for an opinion from this court on that appeal. But these two cases are similar in that I'm arguing the trial court abused its discretion by ordering Mr. Ferguson's sentence for these new convictions to be served in confinement and not in some form of alternative sentencing. So when a trial court is faced with a decision to revoke probation or initially grant or deny probation, the standard is the same. The trial court should ultimately choose what is in the best interest of society and the defendant, as well as what will serve the ends of justice. So in this case, the trial court essentially made its decision to deny probation based on an erroneous assessment of the proof. And that the trial court essentially failed to consider or erroneously weighed several important facts. The first fact would be Mr. Ferguson's dementia symptoms. At the joint sentencing hearing, almost every witness testified that Mr. Ferguson was suffering from some form of dementia or confusion. Even hostile witnesses such as his son Wade, Wade's wife Susan, and their son Donovan all testified that Mr. Ferguson was suffering from dementia And not only that, but that his behavior had deteriorated over the past few years. Frontier Health could not even determine whether Mr. Ferguson was competent to stand trial. They referred Mr. Ferguson's case to Moccasin Bend, which ultimately did decide that he was competent to stand trial. But neither Frontier Health nor Moccasin Bend, gave any sort of diagnosis about his dementia, because that's not what the purpose of their assessment of Mr. Ferguson was. But despite all this, the trial court found that Mr. Ferguson's declining health did not mean he lacked substantial judgment when he committed this crime, or that his old age and ailing mind constituted substantial grounds to excuse his behavior, and essentially just didn't address dementia when it made its decision to deny alternative sentencing. And so the trial court did instead focus on Mr. Ferguson's mistaken belief that he owned his son's property. And obviously this would not excuse his behavior, but that's not what the trial counsel argued in the sentencing hearing. The trial counsel argued that it was the dementia that would constitute substantial grounds to excuse his behavior. And so if the trial court had considered Mr. Ferguson's dementia or weighed it in some way favorable to Mr. Ferguson, then it may have become clear to the trial court that this was a mental health issue rather than a strict criminal justice issue. And probation would have been clearly the more appropriate option, considering Mr. Ferguson could then live out the remainder of his days with his family under the supervision of his son, Wayne, who offered to care for his father. But instead, the trial court disregarded this and treated Mr. Ferguson as a fully culpable defendant, which led it to believe that confinement was the only appropriate solution. The second factor that the trial court failed to consider or erroneously weighed against Mr. Ferguson was his criminal history and the likelihood to reoffend. First, it should be noted that Mr. Ferguson obtained his first felony conviction at 75 years old and was constituted as a range 1 offender. However, the trial court expressed concern that because these past crimes were violent and all centered around this piece of property, that Mr. Ferguson would continue to essentially cause strife and violence surrounding his neighborhood. But in doing so, the trial court disregarded the fact that Wayne, his son, offered to house his father, ensure his compliance, and take him to doctor's appointments. This was an alternative way to prevent Mr. Ferguson from committing further violent acts, but also without sending a 77-year-old man with one leg and dementia to prison for 5 years. So this was the least severe measure necessary, which is a sentencing principle that trial courts are supposed to consider. And it's clear that this would have been the least severe measure necessary in order to provide a just outcome. Furthermore, it's unlikely that Mr. Ferguson would be able to physically travel to his neighbor's property and cause more trouble, given the fact that he's already lost his leg, he's not received physical therapy for a prosthetic leg, and his son Wade, the victim in this case, even testified at trial that Mr. Ferguson had not been able to walk to the fence line or get to the fence line since losing his leg. In addition, Mr. Ferguson is suffering from diabetes, arthritis, and he also has 2 stents in his heart. So he has several health problems that would inhibit him from causing further trouble. Additionally, the trial court found that he would not comply with conditions of probation because he did not comply with a no contact order with the Rosenbaums from the first case. The trial court found that he continued to have contact with them and stalk them by standing on his property or standing at a fence line and merely watching them. However, Mr. Ferguson surely maintained the right to stand on his property and look out beyond his property even while on probation. So I think the trial court erroneously weighed that against him as well.
Or if this wasn't a family dispute, this wouldn't be a contest. It wouldn't seem to me. This man is dangerous to himself and others, just about, from what I can tell. And why can't the judge take every bit of what he did into consideration? Looks like he weighed every one of these factors. How can we overturn that?
Well, the trial court it surely was able to consider past criminal history and his past history with his neighbors, certainly. But certain things have changed since he was last on probation, like the loss of his leg, which inhibited him from causing more trouble. And then his son Wayne's offer, which is significant. Wayne offered to move him to a different property, ensure his compliance, supervise him, and to essentially get him the care he needed for his dementia. And I would argue that we typically don't send, dementia patients to prison. And it's not necessarily the fact that the trial court weighed Wayne's offer or weighed Mr. Ferguson's dementia symptoms and found that on balance, his criminal history outweighed that. It's that the trial court did not even consider, or at least consider on the record, Wayne's offer or at least take Mr. Ferguson's dementia seriously. So that's the problem Mr. Ferguson has with the trial court's denial of probation in this case. And additionally, the trial court failed to consider the risk and needs assessment, which was, albeit from the previous case, but it still considered Mr. Ferguson low risk for reoffending, and the trial court did not consider that either. So if the trial court had considered all these considerations, then maybe it would have come to a different conclusion. But when this court takes into account all these considerations, it should find that the trial court's determination that Mr. Ferguson was better served in prison and that society was better served by essentially having a 77-year-old man in prison for 5 years with one leg and suffering from dementia. This court should find
Rader, let me ask you, make sure I understood what you just said about the prior sentencing report, and it was a low risk of reoffending. Didn't he reoffend, although with a different victim, after that pre-sentence report was prepared?
He did reoffend.
So that assessment was in error. He was a risk to reoffend. Well,
Your Honor, both parties agreed that, I think because the new pre-sentence report had not been prepared by that time, that they would use this old pre-sentence report. And I think it's still significant that the pre-sentence report writer went through other factors about Mr. Ferguson's history and determined on balance that he was a low risk of reoffending. The only two categories Mr. Ferguson scored high in on the pre-sentence report was education, because he did not have I don't think he graduated from high school, and his attitudes and behaviors. And both of those, education has limited relevancy in this case because Mr. Ferguson is 77 years old, he's retired. And then as far as attitudes and behaviors go, that can be explained by this undiagnosed form of dementia. And so the pre-sentence report writer, other than those two categories, would have found him otherwise a low risk in every other category. And I think that should weigh in the trial court's analysis. Maybe he reoffended this time, but taking the fact that the pre-sentence report found him to be a low risk, and Wayne Ferguson's new offer to essentially supervise his father and house his father, I think that should have been part of the analysis as well.
And one more question. If it's undiagnosed, are you saying that there was no medical proof or expert testimony that he actually was suffering from dementia, just lay testimony?
It's just lay testimony. There is no expert medical proof, but it is significant that almost every witness testified that he was suffering from dementia, even witnesses that wanted to see him go to prison for 5 years. So I think that is significant. So ultimately, our argument is that Mr. Ferguson would be better served in the care of his son, where he can receive proper medical attention. He was recently declined parole for the balance of his sentence, so Mr. Ferguson won't be released until he's 82 years old. And so we would argue that the trial court's failure to consider his old age, his mental impairment, and loss of his leg, and Wayne's offer, all of this should have been weighed in Mr. Ferguson's favor for probation. I'd like to now briefly touch on the state's argument regarding the fines. The state has argued in its brief that Mr. Ferguson waived this argument by failing to put on evidence that he had an inability to pay these fines. And while it's true, admittedly, that Mr. Ferguson declined to provide proof of income to the pre-sentence report writer from the first probation case, there was ample evidence of Mr. Ferguson's financial situation throughout the record. He would be 82 years old by the time he was released. He was surviving off of $1,400 Social Security income and retirement income. He is no longer able to work because he has one leg. And in addition, due to his old age and ailing health, it's likely that he will incur, significant medical costs after he's released at 82 years old. In addition,
let me ask you a quick question. Does he own the property where all this took place? Is he a property owner?
He does own the property, although I'm not sure he still owns the property. At the time of the sentencing hearing, he did own the property. Yes.
Okay, so he sold it? Or did he use the money to help pay the fine? Or
I think he may have possibly lost it in his prior divorce.
Mr. Rader, I have
sorry.
Go.
I was just
one more
say
question about fines.
Yes, Your Honor.
I understand when you're talking about restitution, the statute requires the trial court to take into account the ability to earn, the ability to pay. When I instructed jurors in jury trials about fines, I didn't instruct them on that. I just told them that the fine was in the range of blank dollars to blank dollars. Do you have any authority that says the court has to take into consideration his ability to pay to set the fines?
That factor is not a controlling factor, but it does need to consider that in addition to other factors, other sentencing principles. And so I think the state argued in its brief that the trial court considered these other sentencing principles in relation to Mr. Ferguson's sentence, and therefore that applies to this fine as well. But we would argue that the ability to pay is a significant factor that the trial court should consider, especially given Mr. Ferguson's conditions and circumstances. If there are no further questions, Your Honors, I would ask this court to remand for a new sentencing hearing, for the trial court to reconsider some of these factors that it didn't consider, as well as reconsider the $10,000 fine. Thank you, Your Honors.
All right, thank you, Mr. Rader. Right. General?
Good morning, Your Honors, and may it please the court. Alan Groves for the state of Tennessee. While the defendant was on probation for 2 aggravated assault convictions, he attacked his son with a chainsaw while his son was mowing along their common property line. The trial court did not abuse its discretion by ordering this defendant to serve his sentence in confinement, rather than giving him another chance to serve a sentence on probation. The court also properly exercised its discretion by imposing the fine fixed by the jury. The defendant raises several different issues that I'm going to divide into 2 categories. The first category are issues relating to the standard of review, because the Supreme Court has said that in sentencing cases, this court reviews the trial court's decision for an abuse of discretion with a presumption of reasonableness, as long as the trial court's decision reflects that it considered the principles, purposes, and other relevant provisions of the Sentencing Act. And the defendant essentially raises 3 concerns regarding the trial court's consideration of these 3 things. First, he says that the trial court didn't consider the risk and needs assessment as it's required to by statute. But the record reflects that the trial court specifically said that it considered the pre-sentence report in its entirety. That was repeated twice during the sentencing hearing. And the risk and needs assessment And the results of that were within the pre-sentence report. So the defendant's essentially asking this court to disregard the trial court statement that it considered the report in its entirety and just assume that the court considered everything else, but not the risk and needs assessment, which was in the report. So that's just not reflected by the record. Second, the defendant argues in his brief, although I'm not sure it was mentioned this morning, that the trial court didn't specifically say that the defendant was a favorable candidate for probation. But the court did consider the fact that the defendant was eligible for alternative sentencing. And the fact that there's the statute defining a certain class of defendants as favorable is just an advisory sentencing guideline that's not binding on the trial courts anyway. And even if the defendant is favorable under that statute, the trial court still has discretion to deny alternative sentencing if it finds that the defendant failed to carry his burden of proving that he's a suitable candidate for probation. The third point that the defendant raises here is that the trial court didn't impose the least severe measure necessary to achieve the purposes for which the sentence was imposed. And here, the defendant's argument is essentially that the defendant's other son that wasn't attacked, Wayne, who's offering to house the defendant during a period of probation and ensure that he complies with probation again, that's the least severe measure necessary. And that because the trial court rejected that alternative, it erred by not considering that purpose of the Sentencing Act. But the record reflects that the court did consider that as an option, and it just found that was not going to be a workable solution, given the defendant's obsession with his property lines and his belief that he owns some of his neighbor's property. The court specifically found that no matter what it told the defendant to do regarding staying away from his property, that he would find a way to get back to his property, notwithstanding his limited mobility in light of this incident. And so the defendant testified that he would abide by a court order to stay away from the property and to abide by the terms of a probation sentence. But the trial court just disbelieved the defendant's testimony. So this court is really not in a position to second guess that credibility determination. And so all of these things that the defendant is raising really just go towards, did the trial court consider all these general principles and purposes of the Sentencing Act? And because it did, the abuse of discretion standard of review, accompanied by a presumption of reasonableness, does apply in this case. And so the next category of issues that the defendant is raising really goes to the heart of the matter. Did the trial court abuse its discretion when it ordered confinement rather than alternative sentencing? And there's both statutory considerations regarding a trial court's decision to impose confinement, and there's also these common law factors from the electroplating and Parker cases that the Supreme Court has said apply both to judicial diversion cases, but also probation and alternative sentencing cases. And so with regard to the statutory considerations, the trial court specifically identified subsection C in that section 103 of the Sentencing Act as applicable here, which is that measures less restrictive than confinement have been frequently or recently applied unsuccessfully to the defendant. And here, the defendant committed a simple assault against the Rosenbaums in 2009 and received alternative sentencing and entered into an agreed no contact order in 2010, where he and the Rosenbaums agreed just to not have any contact. And he violated that no contact order by standing at the property, watching them, intimidating them, making them feel very uncomfortable. And that was discussed at this sentencing hearing where his probation was revoked in a separate case. And then obviously, as Judge Holloway pointed out earlier, he violated the terms of his probation by reoffending and by attacking his son with a chainsaw. And in the defendant's probation revocation appeal that's pending before the court, I noted in my brief that he conceded that he violated the terms of his probation. arising from his 2017 convictions for aggravated assault. So that concession alone shows that this statutory factor that measures less restrictive than confinement have been recently applied unsuccessfully, that's met here, unquestionably. And you only need one of those statutory factors to justify a sentence of confinement. So that should be dispositive. But the court also went through all of these electroplating factors, as Judge Williams indicated. The court considered basically all of them, went through the list and made findings with respect to each. With regard to the defendant's amenability to correction, the court noted that he never accepted responsibility for this. He still believes that he owns his son's property and some of his other family members' property that live near him. He's had a series of probation violations in the past. The court disbelieved his testimony at the sentencing hearing that he would stay away from the property. And to the extent that the defendant's arguing that his limited mobility, now that he has an amputated leg, would just absolutely prevent him under any circumstances from violating the terms of his probation or from getting back to the property, the trial court just didn't accept that argument. It considered the argument, but it rejected it. And it was reasonable for the trial court to conclude that when someone is so intent on defending what he believes is his, that he would find a way somehow to get back to the property, either on his own or by having someone else take him to the property. He even testified at the sentencing hearing that he had plans to get physical therapy to figure out how to get around on his own. He wanted to travel to go see the Grand Canyon and the Yellowstone National Park. So he definitely has an intention to go places. So the trial court made a reasonable decision that, his new physical circumstances wouldn't prevent him from reoffending in the future. The court considered the circumstances of the offense, which is another electroplating factor. And obviously attacking someone with a chainsaw, running after them while they're on their mower, swinging it in the direction of their head is certainly violent and bizarre. And it caused a lot of trauma to his wife, the victim's wife and son who were watching this incident. They testified that they're still afraid that the defendant might come back and retaliate or, somehow continue to interfere with their quiet enjoyment of their property. The court considered the defendant's criminal history involving violent conduct, and the defendant is trying to focus just on the defendant's prior convictions and the fact that he didn't commit a felony offense until he was 75. But there was a lot of testimony at the sentencing hearing that the defendant was acting out in these types of ways for several years, and that not every time he harassed someone, did it result in a conviction or were charges pressed. So he's been doing this for quite a long time. And the trial court did consider his social history and his mental state, which the court described as confusion. It was correctly pointed out earlier that there was no diagnosis of dementia. And to the extent that the defendant is confused or forgets that he sold off parcels of his property to other family members, even if he forgot that doesn't justify attacking someone with a chainsaw. And the trial court understood that and decided that whatever confusion that he might be experiencing just didn't, sufficiently outweigh the other factors that the court was required to consider in denying alternative sentencing. So even if that finding was erroneous, all the other factors still heavily support a denial of probation. And finally, although I don't believe the trial court specifically mentioned this factor, denying alternative sentencing would have a special deterrent value to this specific defendant. And so if there are no further questions about the issue of the denial of probation, I can address the imposition of the fine as well. Just so the record is clear, the defendant did not object to the amount of the fine, either in his motion for new trial or at the sentencing hearing. And although I don't believe I used the term waiver in my brief, this court has repeatedly found that when a defendant fails to object to that issue in the sentencing hearing or doesn't put on any proof regarding his inability to pay a fine, that is a relevant consideration for sure on appeal. And Judge Holloway, to answer your question, I do agree with my colleague on the other side that the Supreme Court has said that a defendant's ability to pay is a relevant factor for the trial court to consider, but it is certainly not a controlling factor under the Supreme Court's precedents. And that the jury is supposed to, or rather the trial court is supposed to consider all of the purposes and principles of the Sentencing Act when considering whether to impose the fine fixed by the jury. And a defendant's ability to pay is just one of those factors. And here, although the trial court didn't elaborate extensively or repeat its findings regarding the imposition of the fine, it obviously made very extensive findings regarding the circumstances of the offense and defendant's lack of amenability to correction, all of which are also directly appropriate to the fine issue. So notwithstanding the defendant's alleged inability to pay the fine, which again is not, he didn't put on affirmative proof that he lacked the ability. There was this information in the pre-sentence report regarding his Social Security and then an undefined amount of retirement income that he was receiving from his years of employment with the city of Bristol. And then as Judge Montgomery indicated, I believe the evidence in the record showed that he still owned his property. Whether he lost that at some point through divorce proceedings, I don't believe that's in this record, but I would have to go back and double check that. But again, notwithstanding his alleged inability to pay the fine, the trial court's decision was supported by several other factors that it was required to consider. And because that one factor is not outcome determinative, the trial court did not abuse its discretion. So if there are no further questions from the court, we ask the court to affirm the judgment of the trial court.
All right, thank you, John. Mr. Rader, do you have some rebuttal?
Yes, Your Honor. Just briefly, I want to address the state's arguments related to alternative sentencing. The state has said that the trial court never mentioned, or the trial court did consider Wayne Ferguson's offer to supervise his father and care for his father and house his father. But the trial court only came to the conclusion that Mr. Ferguson, no matter what the trial court did, would always go back to this property. But the trial court never did consider, at least on the record, explicitly Wayne Ferguson's offer. It was never addressed by the.
Mr. Rader, is there proof in the record where Wayne Ferguson lived in relation to Wade Ferguson and his father's property?
Wayne Ferguson's address is in the record, but there's no proof in the record about distance. I did look it up. Yeah, I think it's about a 5-minute drive.
Okay, but Wayne didn't get it from his father dividing up a parcel for him, correct?
Wayne sold his.
Maybe get Wade and Wayne mixed up. Let's see. The one that wanted to let him live with him.
Yes, Wayne does not live on that property. He sold his parcel of property in the 90s, I believe. So he doesn't live in that neighborhood anymore.
Okay.
And then the state argues that the trial court considered measures less restrictive, and this is true, or it's true that that factor applied, that measures less restrictive have been tried and failed. But it's our argument that circumstances have changed significantly since then. Wayne's offer obviously changes things to supervise his father, and then Mr. Ferguson's leg. I won't belabor that point, but I just wanted to mention that. And then the state mentions failure to accept responsibility as a significant consideration to the trial court's decision. But this, I think, fails again to acknowledge that Mr. Ferguson is not in his right mind or has an ailing mind due to aging. whether you would call it dementia or confusion, Mr. Ferguson clearly didn't know what was going on. And to hold him responsible and make him accept responsibility for something he may not have the capacity to understand is not appropriate for the trial court, especially in consideration of the trial court. At the trial, Mr. Ferguson, when asked whether he understood he was waiving his right to testify, essentially said, "I don't know what's going on." So I think Mr. Ferguson, whether we call it dementia or confusion, Mr. Ferguson clearly was not in his right mind. And so ultimately, I would ask this court to go back to what serves the best interest of the defendant, what serves the best interest of society, and ask itself whether society is really served by housing an 82-year-old man who's suffering from dementia, isn't getting proper care in a prison where he would be getting proper care with his son, and to let essentially Mr. Ferguson's family handle what is ultimately a familial dispute and care for his ailing father. So if the court doesn't have any further questions, I would rely on my arguments today and the arguments I've made in my brief. Thank you, Your Honor.
Thank you, Mr. Rader. And thank you to both attorneys for participating in oral argument using this format. Our court greatly appreciates your working with us to have your cases heard virtually. All right, we will be in recess then until 11 a.m. Thank you.
This Honorable Court of Tennessee is now in recess.